Okay, good afternoon. Let us discuss the law on partnership. Okay, these are governed by the new civil code. Okay, starting from Article 1767 up to 1867 of the civil code. Okay, bali it consists only of 101 articles. Okay, now we're expecting 10 questions for the October 2020 CPA board exam. Okay, medyo bulk din yung question coming from partnership. Okay, now let us define first partnership. Under Article 1767 of the Civil Code, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Second paragraph, two or more persons may also form a partnership for the exercise of a profession. Bali, yung first paragraph, I'm referring to an ordinary partnership, while second paragraph, I'm referring to a general professional partnership. Now, the distinction between the two is important for tax purpose because an ordinary partnership is taxable as corporation, while a general professional partnership are exempted from income tax. Okay, because the individual, okay, the partnership itself are exempt, but the distribution of income to the partners are taxable in their individual capacity. Okay, now let us distinguish first partnership, okay, from a co-ownership. Okay, di ba pag sinabi kasing co-ownership, there are two or more person who are co-owner of undivided property. Okay, now, first distinction, as to manner of creation, partnership is created by agreement. Kaya nga, di ba sa definition niya, by the contract of partnership. Okay, the rule is that, okay, you cannot create a partnership, okay, by operation of law. Okay, they are created by agreement among the partners. Okay, except only in case of an estoppel. Unlike in case of co-ownership, it can either be created by agreement or it can be created by operation of law. Like for instance, A and B, okay, they agree, okay, to buy a parcel of land by contributing 500,000 each for their common enjoyment. In that case, A and B becomes co-owner of undivided property by agreement. Okay, another example, A die, okay, meron siyang parcel of land, consists of 1,000 square meter, left to his legal heirs X and Y. In that case, X and Y becomes co-owner of undivided property by operation of law through succession. Second distinction, as to juridical personality, ang partnership, meron siyang juridical personality separate and distinct from the partners composing, okay? Partners composing it. Okay? Now, ang co-ownership, wala siyang separate juridical personality. Okay? Kaya halimbawa, ABC, they form ABC partnership. In this case, there are now 4 persons. ABC as natural person and ABC partnership as a juridical person. Unlike doon sa co-ownership, if ABC are co-owner of undivided property, there are only 3 persons, A, B, and C lang. Okay, there is no separate legal personality for the co-ownership. Third distinction as to purpose, ang partnership kasi, ang purpose niyan is mag-generate ng profit. Okay, there is no such thing as partnership for non-profit purpose. Kaya nga doon sa definition, di ba? By the contract of partnership, two or more persons bind themselves to contribute money, property, interest to common fund with the intention of dividing the profit among themselves. Kaya ang major objective ng partnership, mag-generate ng profit, although losses may be incident, okay, to its operation lang. Okay, kaya kung halimbawa ang purpose is non-profit, you better organize a non-stock corporation, not a partnership. Samantalang sa co-ownership, ang purpose niya is the common enjoyment of undivided property lang. Next, as to duration, ang partnership, walang limit. Okay? As long as all partners are still alive. Kaya halimbawa, si ABC nag-form ng partnership, walang fixed term. Okay? Lumalabas, tinatawag siyang partnership at will. Kaya pwede siyang i-dissolve at any time, okay, without committing a breach of contract. Okay, pero wala siyang limit as to period. As long as all partners are still alive. Kasi yung death ng any partner is a ground for automatic dissolution. Pero sa co-ownership, the rule is that the co-owner cannot stipulate that the property be undivided for more than 10 years. In fact, the donor or the testator, okay, may impose that the partnership be undivided for not more than 20 years naman. Kaya si A, nag-donate ka ng property kay X and Y, tapos nakalagay doon sa deed of donation na yung property hindi pwedeng i-partition for 15 years, that is valid. Okay, kasi yung donor testator pwedeng mag-impose that the property be undivided for a period not more than 20 years naman. Another is as disposal of interest. Sa partnership kasi, a partner may dispose his interest in the partnership, but the transferee does not become a member of the partnership. Ang tawag sa kanya is assignee of interest lang. Kaya pag assignee of interest, ang right lang niya ay tumanggap lang ng shares of profit and surplus upon dissolution. Pero the assignee of interest has no right to participate in the management. Okay, wala kang right na mag-demand ng true and full information regarding partnership affair. Wala siyang right mag-demand ng formal accounting. Okay, samantalang doon sa co-ownership, okay, a co-owner may dispose his interest to third person as to make the transferee a co-owner of undivided property. Okay, next, okay, power to act with third person. Sa partnership kasi, pag walang appointed manager, all partners are considered agent of the partnership. That's why a partner can bind the partnership as well as the other partners. Kumbaga parang agent siya ng partnership as well as the other partner. Okay, kaya may mutual agency. Samantalang sa co-ownership, okay, a co-owner cannot represent the other co-owner kasi walang right of representation. Last effect of death, sa partnership, yung death ng any partner is a ground for automatic dissolution. Okay, kasi ang natatransfer lang sa legal heirs is only interest in the partnership but not the right as a partner. But in a co-ownership, if a co-owner die, then his interest is simply transmitted to the legal heirs by operation of law. Okay, now next, let us proceed sa distinction naman between partnership and the conjugal partnership of gain. Pag sinabing conjugal partnership of gain, di ba ito ay isang property regime between husband and wife? Okay, na if okay, the marriage was celebrated before August 3, 1988, okay, then kung walang agreement between property regime within husband and wife, they are governed by the conjugal partnership of gain. Pero kung halimbawa, okay, yung marriage was celebrated August 3, 1988 and onward, okay, in the absence of any prenuptial agreement between, okay, the husband and wife, then they are governed by the absolute community of property. Now, what are the distinction? Okay, number one, as to parties. Sa partnership kasi, ang parties ay two or more. Okay? Now, sa conjugal partnership of gain, the only parties here is the husband and the wife. Third parties are not allowed. Okay, pangalawa, laws which govern, ang partnership is governed by agreement. Siyempre, wag lang siyang contrary to law, moral, good custom, public order, saka public policy. Kasi remember, ang limitation lang ng freedom of contract, okay, yung Article 1306. Kasi di ba sabi doon, the contracting parties may provide for stipulation, clauses, terms, and conditions as may be deemed convenient, provided not contrary to law, moral, good custom, public order, and public policy. Kaya lumalabas ang partnership ay governed by agreement among the partners. But ang conjugal partnership of gain, hindi yan subject sa stipulation. These are governed by law. Next, as to juridical personality, ang partnership, meron siyang juridical personality separate and distinct from the partners composing it. Sa conjugal partnership of gain, wala siyang separate juridical personality. Commencement. Ang partnership, magko-commence yan from the time of execution ng contract of partnership unless the partners agree to commence the partnership at some other time. In other words, yung commencement ng legal personality ng partnership subject to stipulation. But in a conjugal partnership of gain, it will commence at the time of celebration of the marriage. In fact, okay, stipulation between husband and wife that the conjugal partnership of gain will commence at some other period is null and void. Next, as to purpose in partnership, the purpose is primary to generate profit. I repeat, all the losses may be incident to its operation. Samantalang sa conjugal partnership of gain, okay, ang purpose lang yan is the common, okay, enjoyment of the conjugal fund. Next, distribution of profits. Sa partnership, ang profit and loss, dinidistribute yan based on agreement. Okay? However, okay, kung may agreement ng profit but there is no agreement ng losses, then the losses will be distributed same as the profit ratio. Pero pag totally walang agreement ng profit and loss, then the profit and loss will be distributed based on respective capital contribution. But the industrial partner are exempted from losses. As to profit naman, the industrial partner will receive a just share in the profit. However, if the industrial partner also contributed capital, after receiving a just share in the profit, then the balance entitled siya to receive based on their respective capital contribution. In a conjugal partnership of gain, the profit and loss is distributed, okay, between the husband and wife equally. Okay, next, as to management. Sa partnership, if there is no appointed manager, all partners are considered as managing partner. That's why all of them as a rule can perform all act of administration but not strict dominion. Pero sa conjugal partnership of gain, okay, ang management ng conjugal partnership of gain is okay, both to the husband and wife, given to both husband and wife. But in case there is conflict, the decision of the husband prevails. Next, disposition of shares. In partnership, a partner may dispose his interest in the partnership. But I repeat, the transferee does not become a member of the partnership. Ang tawag sa kanya ay assignee of interest lang. Pero sa conjugal partnership of gain, of course, the husband and wife are prohibited to dispose their shares in the conjugal fund. Another is the distinction between partnership and a voluntary association. Okay, di ba pag sinabing voluntary association, these are group of person, okay, na nag-form, okay, with no separate juridical personality kasi hindi naman nila comply ang requirement to have a valid corporation. Okay, kaya what are the distinction? Number one is in partnership, meron siyang juridical personality. Ang voluntary association, there is no separate juridical personality. Pangalawa, ang purpose ng partnership mag-generate ng profit. But in voluntary association, there is no purpose of profit. Next, in a partnership, okay, there is a contribution of money, property, or industry to a common fund. But in a voluntary association, there is no contribution of money, property, or industry to a common fund, although may tinatawag na membership dues. Okay, last, liability of members in partnership. Since ang partnership meron siyang juridical personality separate and distinct from the partners composing it, the liability of the partners is pro rata and subsidiary. Bakit ko sinabing pro rata and subsidiary? Because, okay, subsidiary in the sense that partnership creditor cannot go directly to the individual partners. Kailangan mo na lang i-exhaust lahat ng asset ng partnership. Pag na fully exhaust na, then to make all partners liable, pro rata. Pro rata, which is a joint obligation. Pero sa voluntary association, since ang voluntary association has no separate juridical personality, then the individual members are liable in their individual capacity. Now, what are the characteristic of partnership? Okay, ang first characteristic ng partnership is it is consensual. Because partnership is perfected by mere consent. Kaya once na present na yung essential element ng contract under 1318, which is the consent, the object, and the cause, then the contract of partnership is now perfected. Okay, of course, with the exception of Article 1771 in relation to 1773. Kasi whenever there is contribution of immovable property, there must be an inventory of the real property signed by the partners and attached to the public instrument. Kasi failure to comply this requirement would render the contract of partnership void. In that case, it becomes a formal contract. Pero by the way, nag-a-apply lang siya once na may contribution ng immovable property. Pero take note, yung Article 1772, hindi siya formal contract. Kasi di ba sabi ng 1772, every contract of partnership having capital of 3,000 pesos or more must be in a public instrument and registered before the SEC. Pero even though you fail to comply those public instrument, okay, there is still a valid partnership. Yun nga lang, hindi mo siya mare-register. Kasi para ma-register, kailangan merong public instrument. Pero pwede mong i-exercise yung rights sa 1356 wherein you can compel the other partner to observe the form. Okay, to execute the necessary public instrument because the public instrument is only for purpose of convenience. Next, it is nominate because there is a name under the law. Tinawag siyang contract of partnership. As to distinguish from innominate contract wherein there is no name or designation under the law. Kung nare-recall niya, yan yung duot des, duot facias, faciot des, and the faciot facias. Pero take note that duot des is no longer an innominate contract because under the present law, which is the new civil code, okay, nire-recognize na yan as a contract of barter. Bilateral siya because okay, ang partnership by obligation sa individual partners and the individual partners has also obligation to the partnership. Onerous because there is there is a burden kasi required ang partners mag-contribute ng money, property, or industry to common fund. Cumulative kasi meron siyang equivalent value given. Kasi yung kinontribute ng partners na money, property, and industry to common fund, meron silang equivalent capitalization. Principal, because ang partnership, okay, it can stand alone. It means hindi siya dependent upon existence of another contract. Okay, as to distinguish from accessory contract, wherein these are contracts that are dependent only upon existence of principal obligation. By the way, na-discuss natin yung mga accessory contract before, yung okay, contract of guarantee, contract of surety, pledge, chattel mortgage, real estate mortgage, saka antique resist. But partnership is a principal contract. Okay, another is it is preparatory. Why? Because once the partnership is perfected, it's not the end. Okay, that is only the beginning to enter into another contract. Kaya lumalabas yung perfection ng partnership dito, kumbaga necessary preparation lang yan para mag-enter another contract like contract of sale, contract of lease, okay, and so and many other contracts. Okay, now, punta tayo sa forms. Okay, sabi ng 1771, a partnership may be constituted in any form, except when immovable property or real rights are contributed thereto, in which case a public instrument thou shall be necessary. Kaya na-emphasize lang ng 1771 na ang contract of partnership ay consensual. Pero once may nag-contribute na ng immovable property or real rights, then okay, it becomes a formal contract. Kasi kailangan nyo na ng inventory ng real property signed by the partners and attached to the public instrument. Otherwise, the contract of partnership is void. Okay, di ba sabi natin doon before sa contract, pag formal siya, kailangan may consent, object, cause plus the form. Kasi failure to comply the form prescribed by law would render the contract of partnership void. Kaya pag binasa mo yung Article 1773, sabi dyan, a contract of partnership is void whenever immovable property is contributed thereto, if an inventory of said property is not made, signed by the parties, and attached to the public instrument. Kaya dito sa 1773, in relation to 1771, naging formal contract na siya. Kaya pag may nag-contribute ng immovable property or real rights, okay, dapat merong inventory ng real property signed by the partners and attached to the public instrument. Pero I repeat, in 1772, hindi to formal contract. This is only for purpose of convenience. Only for purpose of registration. Okay? Kaya sabi dyan, every contract of partnership having capital of 3,000 pesos or more in money or property shall appear in a public instrument which must be recorded in the office of the Securities and Exchange Commission. Pero sabi dyan, failure to comply with the requirements of the preceding paragraph shall not affect the liability of the partnership and members thereof to third person. Kaya ibig sabihin, kung hindi mo na-comply yung public instrument dito, okay, lumalabas, okay, hindi mo siya mare-record sa Security and Exchange Commission. Pero sabi ko nga, okay, since ang purpose ng public instrument is only for convenient, then you can compel the other party to observe the form. Kasi kung hindi mo siya na-registered sa SEC, may valid partnership pa rin. Okay? Kasi nga, ang partnership is consensual. Ang tawag sa kanya, unregistered partnership lang. Okay? Now, what are the requisites of a valid partnership? Okay, para magkaroon daw ng valid partnership, the following requisite must be present. First, kailangan may valid contract. Siyempre, para magkaroon ng valid contract, dapat all essential element of contract under 1318 must be present. At kung nagkaroon ng contribution ng immovable property or real rights, dapat na-comply ang form under Article 1771 saka 1773. Okay, which is a public instrument at yung inventory ng real property. Second, there must be a lawful object or purpose. Kasi pag ang object ng partnership is unlawful from the very beginning, void or non-existing partnership. Pero pag ang object ng partnership ay lawful from the beginning but subsequently naging unlawful, ground dyan for automatic dissolution. Another, there must be contribution of money, property, or industry to common fund. Kasi without contribution of money, property, or industry to common fund, then the partnership becomes useless. Okay, next, there must be intent to divide the profit among the partners. Kasi remember, ang primary objective ng partnership is mag-generate ng profit. All the losses may be incident to its operation. And last, it must be established for the common benefit or interest of the partners. That's why under 1799 nga, the partners cannot stipulate that the property, the partners cannot stipulate excluding any partners from the share in the profit or loss. Kaya halimbawa, si ABC, nag-agree na since A is a multi-billionaire, A will no longer share in the profit. Gawin na lang 50-50 kay B and C. Now, such stipulation actually is null and void. Kaya lumalabas as if wala silang agreement ng distribution ng profit and loss. Therefore, the profit and loss will be distributed based on their respective capital contribution. Okay, now balikan natin yung first requirement. Kailangan daw ng valid contract. Sabi ko nga, para magkaroon ng valid contract, dapat all essential requisite ng contract must be present. Okay, kasi dyan din magko-commence yung legal personality ng partnership. Kasi under 1784, sabi dyan, a partnership begins from the moment of the execution of the contract unless it otherwise stipulated. Kaya mapapansin mo, nakalagay dyan, unless it otherwise stipulated, therefore subject to agreement yung commencement ng legal personality. Kaya halimbawa, ABC may agree that the partnership will be formed 1 month from today. Kaya lumalabas today, wala pa siyang separate juridical personality kasi magko-commence yung legal personality upon arrival of period. Kasi subject yan sa tinatawag na suspensive period. Under 1777, sabi niyan, association and societies whose articles are kept secret among the members and wherein any one of the members may contract in his own name with third persons shall have no juridical personality. Example, halimbawa si ABCDE nag-form ng association, ex-association. Okay, ang problema, wala siyang article. Kung may article man, walang nakakaalam kay A, B, C, D, E. And each of the members A, B, C, D, E may enter into a contract with third person in their own name, not in the name of X association. Sabi ng batas, itong si X association, wala siyang separate juridical personality. Kaya lumalabas, all members of this association are liable in their individual capacity. Second, there must be a lawful object or purpose. Sabi ng batas, a partnership must have a lawful object or purpose and must be established for the common benefit or interest of the partners. Kasi tandaan nyo, pag ang object ng partnership is unlawful from the beginning, then that is a non-existing partnership because the partnership is null and void. Pero halimbawa, ang object ng partnership is lawful from the beginning but subsequently it becomes unlawful, ground lang siya for automatic dissolution, okay, under Article 1830 of the Civil Code. Kasi pag binasa mo yung 1830, sabi dyan, isang ground ng automatic dissolution, any event which make it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership cause for automatic dissolution of the partnership. Ngayon, sabi ng Article 1770, when an unlawful partnership daw is dissolved by a judicial decree, the profits shall be confiscated in favor of the state, without prejudice to the provision of the penal code governing the confiscation of the instrument and effect of a crime. Pero ang question kasi dyan, kailangan pa ba ng judicial decree? Kung ang object ng partnership is unlawful from the beginning, hindi na, di ba? Kasi null and void naman siya, non-existing. Pero walang masama kung magkakaroon ng judicial decree for convenient din ng parties. Okay? Now, sinasabi lang ng 1770, okay, kapag ang unlawful partnership ay dinisolve by a judicial decree, okay, yung profit, i-confiscate in favor of the state. O syempre may question ka, sir, how about capital? Yung capital, i-return siya. Unless, of course, okay, when the capital become an instrument effect of the crime, in that case, it will also be confiscated in favor of the state. And if that is obnoxious, okay, yung principal, sabihin yung principal, ano yan, naging, ano na siya, effect of the crime na. At yan ay obnoxious or injurious to public health or public safety, then it will be destroyed through exercise of police power of the state. Next, kailangan daw may contribution ng money, property, or industry to common fund. Kasi without contribution of money, property, or industry to common fund, I repeat, the partnership becomes useless. Mangyari dyan, magtitinginan lang sila. Walang money, walang property. Kutsa pati industry. Ang industry pwedeng physical or mental industry. Maski idea, wala silang makontribute. Okay? Kaya lumalabas, wala raw partnership. Ngayon, sabi ng Article 1790, unless there is stipulation to the contrary, the partner shall contribute equal shares to the capital of the partnership. Okay, ano ibig sabihin yan? Okay, ibig sabihin lang yan, okay, kung wala tayong agreement ng different capital contribution, ang presumption ng batas, all partners will contribute equal capital. Kaya, ibig sabihin, meron tayong conclusion. Pag walang agreement ng distribution ng profit and loss, wala ring agreement ng okay, capital contribution, then the profit and loss will be distributed equally among the partners. Kasi remember, may presumption tayo under the law, okay, na kapag walang agreement ng different capital contribution, the presumption is that all partners contribute equal capital. At ang sabi ng batas, kung walang agreement ng distribution ng profit and loss, the profit and loss will be distributed based on respective capital contribution. Eh may presumption na equal contribution, kaya lumalabas, equal ang distribution ng profit. Okay, ngayon, sabi dyan, if there is no agreement to the contrary, in case of an imminent loss of the business ng partnership, any partner who refuses to contribute an additional share to the capital except an industrial partner to save the venture shall be obliged to sell his interest to the other partners. Now, example class, A, B, C, D, E, they form a partnership. Tawagan natin ABC partnership. However, because of continued losses, okay, nag-suffer ng partnership ng imminent loss. Because of continued losses, kinakain na ng losses yung capital ng partnership. That's why in order to save the venture, okay, kailangan mag-contribute ng additional capital. Ang problema, si A, B, C, D, kunwari si A, industrial partner. B, C, D, E are capitalists. Ngayon, nag-decide si B, C, D, E na magbigay ng additional capital contribution. Pero nag-refuse si A. Question, can A be compelled to sell his interest to the other capitalist partner? The answer, of course, is no. Kasi A is an industrial. Pero halimbawa, si B yung nag-refuse na magbigay ng additional capital contribution, okay, then pwede siyang i-compel na ibenta yung kanyang interest with the other capitalist. Now, ang reason daw dito is that ngayon yung partnership nagsasuffer ng imminent loss, ayaw mo magbigay ng additional capital contribution, and if later on the partnership, okay, realize profit, okay, gusto mo mag-share sa profit. Kaya pwede kang i-compel na ibenta yung interest with the other capitalist partner. Reason for lack of interest. Pero by the way, paano kung halimbawa si B, okay, willing naman talaga siyang magbigay ng additional capital. Pero wala na siyang capability. Puros willingness lang. Ang tanong, pwede bang i-compel si B na ibenta yung kanyang interest with the other capitalists? The answer is no. Kasi pag binasa mo yung nakalagay sa batas, according to Manresa, yung word refuses dito, dapat refusal without any justifiable reason. Kasi kung justified naman, yung partner not to give additional capital, kasi wala na nga siyang capability to give additional capital contribution, then he cannot be compelled to sell his interest to the other capitalist partner. Pero kung meron siyang capability naman, pero yun nga, ayaw lang niyang magbigay ng additional capital contribution to save the venture, then pwede siyang i-compel na ibenta yung kanyang interest with other capitalists for lack of interest. Now, if one of the partners now refuse to give contribution, the other partner may compel him to deliver what he has promised. Example lang. Halimbawa si ABC nag-form ng partnership. Tawagan natin ABC partnership. Si A nag-promise na contribute ng specific parcel of land. Si B naman, pang personal property, and si C is cash. Okay, ang problema, si A nag-refuse na i-deliver, okay, or sabihin natin si B, nag-refuse na i-deliver yung mga personal property pre-promise niya. Anong remedy ngayon, class, sa part ni A and C? Answer, only for specific performance. To compel B to deliver, okay, the specific property that he promised. Now, by the way, kung babalikan niyo yung sa obligation, okay, ang remedy kasi class ng creditor, di ba number 1 is specific performance. Okay, pangalawa, pwede ring rescission kung yan ay reciprocal obligation. At pangatlo, pwede ka mag-ask ng pure damages. But under the law on partnership, okay, ang specific remedy lang ng partner, pag ang other partners nag-refuse na magbigay ng, okay, i-deliver yung kanilang respective capital contribution, the only remedy is only specific performance plus damages, if any. Pero hindi pwedeng rescission as well as pure damages. Kasi ang reason dito, walang mapo-form na partnership for lack of capital contribution. Ngayon, sabi ng Article 1830, Paragraph 4, the partnership is dissolved when a specific thing which a partner had promised to contribute to the partnership perishes before delivery. In any case, by the loss of the thing, when the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use or enjoyment of the same. But the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. Okay, now ganito yun. No sa 1830 paragraph 4, meron tayong 4 scenario. Okay, halimbawa, si A, nag-promise na mag-contribute ng determinate object. Pero ang agreement is that ililipat niya ang ownership sa partnership upon delivery. Sabi ng batas, pag ang object na yon ay na-lost before delivery, the partnership is dissolved. Reason for lack of capital contribution because of loss of the thing due. Pero kung na-lost daw yung determinate object after delivery sa partnership, hindi siya magkakos ng dissolution, but the partnership will suffer the risk of loss under the doctrine of res perit domino. Kasi upon delivery to the partnership, ownership now pass to the partnership. Kaya meron ng capital contribution. E biglang nawala, kaya hindi siya magkakos ng dissolution. Pero pag ang partner ay magko-contribute ng determinate object wherein only the use will be transferred to the partnership, either malos yan before or after delivery, ground siya for automatic dissolution. Reason, lack of capital contribution. Kasi since ang i-contribute na ay use lang nung object na yon, nung determinate object, since nawala yung determinate object, wala rin siyang contribution. Kaya lumalabas, the partnership is dissolved under Article 1830, Paragraph 4. Ngayon, merong tinanong before sa CPA board exam. Sino ba ang dapat mag-suffer ng risk of loss? Ngayon, kung na-loss yung object before delivery, walang duda. The partner will suffer the risk of loss under the doctrine of res perit domino. The thing perishes with the owner. Pero ang question, what if na-loss yung object after delivery? Sinong dapat mag-suffer ng risk of loss? Ngayon, under the law, pag ang i-contribute ng partner is determinate object wherein only the use is transferred to the partnership. Kaya lumalabas, ang ownership ni-retain pa rin ng partner. The partner will suffer the risk of loss. Pero kung i-contribute ng partner ay specific and determinating wherein ownership will be transferred to the partnership upon delivery, then the partnership will suffer the risk of loss. O kaya ang i-contribute ng partner ay fungible. Cannot be kept without deterioration, contributed to be sold, brought and appraised in the inventory. Lahat yan ang magsasuffered ng risk of loss is the partnership. Now, why? Anong reason? The reason is that kasi pag ang kinontribute ng partner itong mga item na to, it presuppose that ownership pass to the partnership upon delivery. Kaya dapat ang mag-suffered ng risk of loss is the partnership under the doctrine of res perit domino. Kasi katulad nito, okay, contributed to be sold. Ang tanong kasi, how can the partnership, okay, sold the object? Okay, how can a partnership dispose it to a third person if there is no transfer of ownership? Kaya lumalabas, it presupposes that ownership is transferred to the partnership upon delivery of this object. Kaya lumalabas, ang dapat mag-suffer ng risk of loss is the partnership. Another is there must be intention to divide the profit among the partners. And sabi nga natin, sabi ng batas, profit or losses shall be distributed in conformity with agreement. Kaya ibig sabihin sundan ang agreement sa distribution ng profit and loss. Pero take note, ang limitation niyan yung 1799. Okay? Kasi any stipulation excluding any partners from the share in the profit or loss is void. Ngayon, kung meron daw agreement ng profit but there is no agreement as to losses, then the losses will be distributed same as the profit ratio. Kasi ang sabi ng batas, if only the share of each partner in the profit had been agreed upon, the share of each in the losses shall be in the same proportion. Kaya kung agreement nyo lang, distribution ng profit, walang agreement ng distribution ng losses, yung losses daw, i-distribute same as the profit ratio. Pero baka tanungin nyo, sir, paano kung may agreement ng losses, walang agreement ng profit? Okay, paano i-distribute ngayon yung profit? Okay, ngayon, hindi kasi nilagay sa batas yan. Kasi remember, ang primary objective ng partnership is not to generate losses, but to generate profit. Kasi yung losses ay incident lang doon sa operation. Saka ba't ka naman magpo-form ng partnership kung maglo-loss lang kayo? Kaya hindi yan nilagay sa batas. Pero syempre, ang tanong nga, what if theoretically, okay, or meaning hypothetical question, tinanong siya. Okay, I think the better answer is i-distribute yung okay profit same as the loss ratio para maging more equitable siya. Although walang nakalagay sa batas. Pero pwede mo rin kasing i-argue, of course, na dapat, okay, kung halimbawa, okay, dapat i-distribute yung profit based on respective capital contribution. Pwede mo rin gawin siyempre yung argument kasi walang agreement ng distribution ng profit. Pero I think the better answer should be para maging more equitable siya, kailangan i-distribute siya same as the loss ratio. Okay? Ngayon, ito namang paragraph 3 kasi ang sinasabi, in the absence of stipulation. Kaya kung talagang totally walang agreement sa both profit and loss na to, the share of each partner in the profit and losses shall be in proportion to what he may have contributed. Kaya itong third paragraph nag-a-apply kung talagang totally walang agreement ng profit and loss. Okay? Shall be in proportion daw to what he may have contributed. Okay, but the industrial partner shall not be liable for the losses. Kaya lumalabas, ine-emphasize lang ng batas ng industrial partner, exempted siya from losses. Kasi ang reason daw dito is that actually ang industrial partner already share in the losses. Kasi tingnan nyo ha, despite, di ba, na nag-contribute ka ng industry, nag-exert ka na ng effort, time. Okay, tapos later on, fruitless pala kasi walang na-generate na profit. Kaya actually, the industrial partner already share in the losses. Okay? Ngayon kung halimbawa, sabi dyan, as per profit, the industrial partner shall receive such share as may be just and equitable under the circumstances. By the way, under the old civil code kasi, ang pagdating kasi sa profit, ang share ng industrial partner kung ano yung pinakamababang share ng capitalist partner. Yan yung nakalagay sa old civil code. But under the new civil code, tinanggal na yan. Ang nilagay na lang dito yung profit, okay, ng industrial, ang share sa profit ng industrial partner, okay, would be just and equitable under the circumstances. Kaya sino magde-determine yan? Answer, of course, yung partners. Pero kung halimbawa, hindi talaga ma-determine, okay, nagkaroon ng disagreement among them, then the court may determine what is just and equitable under the circumstances. Sabi niyan, if beside his service daw, meaning ito, industrial ka, nag-contribute ka pa ng capital, after receiving a just share in the profit, okay, makakatanggap ka ng, okay, doon sa balance, makakatanggap ka based on respective capital contribution. Ngayon, okay, there is a question before in the CPA board exam. Tinanong tong case ni Criado versus Gutierrez Hermanos. ABC were partners, the first one being an industrial partner. Now, during the first year of operation, the firm made a profit of 300,000. During the second year, a loss of 150,000 was sustained. Thus, the net profit for the 2 years of operation was only 150. In the article of partnership, it was stipulated that A, the industrial partner would get 1/3 of the profits, but not participate in the losses. Question, how much A will get? Is this 1/3 of the 300,000 or is that 1/3 of 150 lang, which is the net profit? Okay, answer, okay, 1/3 of the 150 lang. Okay, kasi even though an industrial partner daw are exempted from losses, but it does not refer to one or more specific transaction. Kaya lumalabas, dapat 1/3 lang nung net, which is 150. Okay, kasi unfair nga naman, di ba, kung i-check ninyo, di ba, 300,000. Meron kang 1/3 ng profit. Nung second year, may loss naman ng 150, wala ka ng share. Okay? Parang ano lang yan, parang ganito. Halimbawa, yung partnership, meron lang 3 transaction. First transaction, profit. Second transaction, profit. Third transaction, loss. Ibig bang sabihin yung industrial partner, magtatanggap ka ng share sa profits sa first and second transaction, pero wala kang share sa losses on third transaction. Actually, kung titignan mo ang profit lang talaga ng venture, okay, is yung summation of course nung first, second, and third transaction. Parang ganon din dito. Kung ang partnership ay with a fixed term for 2 years lang, May profit ka ng 300,000 ng first year, may loss ka ng second year. Therefore, ang profit lang talaga ng venture in total is only 150. Kaya dapat may share ka sa 1/3 lang ng 150. Pero halimbawa, ang profit ng first year is 150, second year may loss na 300, thereby there is a net loss of 150. Exempted ka because you are industrial. Pero kung halimbawa, nakalagay kunwari for instance a problem na okay, specific na year-to-year basis, then sundan niya yung stipulation. Bawa, first year, okay, talagang ano siya, pag year-to-year basis, ang distribution niya, ibig sabihin, year-to-year basis, profit, 300, meron siyang 1/3. Pagdating sa loss, exempted siya. Okay, that is also a valid stipulation. Next, okay, question muna, yun bang designation ng distribution ng profit and loss? Pwede ba siyang i-left sa any partner? Okay, the answer of course is no. Kasi mababiolate yung doctrine of mutuality of contract. Kung nare-recall nyo dun sa Article 13 o 8 ng Civil Code. Di ba sabi doon, contract must bind both contracting parties. Its validity and compliance cannot be left to any one of them. Kaya ibig sabihin ko, magde-determine lang ng distribution ng profit and loss is on the one of the partner without the consent of the other. Lumalabas, okay, void siya for total absent of consent. Pero ang tanong, pwede bang i-left sa third person ang pag-distribute ng profit and loss? The answer is yes. Kasi di ba doon sa 1309, the determination of performance may be left to a third person whose decision shall not be binding until it has been communicated to both contracting parties. Kaya sabi nga ng batas dito, the designation of losses and profit cannot be entrusted to one of the partners. Kaya pag halimbawa si ABC, okay, ang agreement nila, si A lang ang magde-determine ng distribution ng profit and loss. At dinistribute niya ng 50-30-20. Void siya. Lumalabas as if walang agreement ng distribution ng profit and loss. Kaya yung profit and loss, i-distribute nyo based on respective capital contribution. Pero kung halimbawa, pinix for instance ni A na 50%, 30%, 20% at pumayag si BC. In that case, meron ng real consent. In that case, binding siya. Ngayon, kung halimbawa si ABC nag-agree na si X ang magde-determine ng distribution ng profit and loss, valid naman siya. Pero kung halimbawa, dinetermine ni X na ang distribution ay 50-30-20 kay ABC, binding na ba siya? Hindi pa, hanggat walang communication. Pero pag na-communicate na ni X kay ABC na ang distribution ng profit and loss is 50-30-20, binding na siya. Pero question, can ABC impugn the determination of third person? The answer is yes. If that is evidently inequitable. Pero remember, under the law on partnership, may dalawang instances wherein the partners can no longer impugn the determination of third person. Number one, when the partnership already execute the distribution of profit and loss. Bakit? Kasi estopel na kayo. Kasi hindi pala kayo agree, ba't nyo in-execute? And second, when the partners failed to impugn the determination of third person within 3 months from knowledge. Kaya ibig sabihin, kung alam na niya, na-inform na siya na ang share niya ay 30%, binibigyan lang siya ng batas ng 3 months para questionin yung determination ng third person. Otherwise, it becomes binding. Now, according to Manresa, yung 3 months dito is sufficient enough na para questionin ng partner yung determination ng third person. Okay? In action na to sa part niya. Kasi sufficient enough na raw yung 3 months dito para ma-question niya yung determination ng third person. Para hindi raw ma-impede, of course, yung partnership operation. Kaya yan sabi ng 1798, basahin natin yung exact word ng law. Sabi dyan, if the partners have agreed to entrust to third person the designation of the share of each one in the profit and losses, such designation daw may be impugned only when it is manifestly inequitable. Pero ito yung dalawang instances wherein the partners can no longer impugn the determination of third person. Sabi dyan, in no case may a partner who has begun to execute the decision of third person or has not impugned the same within a period of 3 months from the time he had knowledge thereof, complain of such decision. And of course, the last requirement to have a valid partnership, it must be established for the common benefit or interest ng partner. Kaya sabi ng 1770, establish, ang sabi ng 1770 a partnership must have a lawful object or purpose. And it must be established for the common benefit or interest ng partners. Now, under 1799 nga, sabi dyan, a stipulation which excludes one or more partners from any share in the profits or losses is void. Kasi halimbawa, sabi ko nga si ABC nag-form ng partnership. Okay, since si A is multi-billionaire, ang agreement nila, A will no longer share in the profit. Tapos, hahatiin na lang ni BC ng 50-50 yung share sa profit. Now, in that case, as if wala silang agreement ng distribution ng profit and loss, therefore, the profit and loss will be distributed based on respective capital contribution. Pero baka tanongin mo, sir, sandali, paano kung ganito? Si ABC nag-agree na ang share ni A 2%, si BC 49% each. Okay, valid na ba siya? Answer, void pa rin siya. Kung ang intention of course dito ay i-circumvent lang ang provision ng 1799. Kasi napaka-basic sa batas na what cannot do directly, cannot do indirectly. Especially kung si A, kunwari, malaki yung capitalization niya, pero ang share lang niya 2% just to circumvent the provision under 1799. Pero take note, stipulation excluding any partners from the share of the profit, void. Second, stipulation excluding capitalist partner from share sa losses, okay. Ulitin natin Stipulation excluding any capitalist partner from the profit, void. Second, stipulation excluding any capitalist partner from losses, void. Number 3, stipulation excluding any industrial partner from profit, void. And stipulation excluding industrial partner from losses is valid. Okay, reason because the law itself exempt an industrial partner from losses. Pero kung capitalist yan, exclude mo sa profit and loss, void. Okay? Pero pag industrial, stipulation excluding sa profit, void. Pero excluding from losses, valid. Ngayon, pero take note ang void nga pala dito, I repeat, is not the partnership itself, but only the agreement sa distribution ng profit and loss. Kaya lumalabas as if walang agreement ng distribution ng profit and loss, therefore the profit and loss will be distributed based on respective capital contribution. Now, let us proceed now sa presumption. Sabi dito, persons who are not partners as to each other are not partners as to third persons, except estupel. Ibig sabihin, kung si A and B nga, hindi sila partners as to each other, hindi sila partner sa isa't isa, dalalong hindi kayo partner kay C, a third person, except estupel. Kasi diba, A and B are not partners, pero nag-misrepresent sila kay C that they are partners. Under the law, A and B becomes partners by estupel. Pangalawa, co-ownership daw or co-possession does not of itself establish a partnership, whether such co-owners or co-possessor do or do not share in any profit made by the use of property. Example halimbawa si A namatay, tapos meron siyang naiwan kunwaring property kay X and Y. Now, under the law, X and Y becomes co-owner of undivided property by operation of law. Ang problema, yung mga property naiwan dito ni A kay X and Y, nag-generate ng profit at dinistribute ito kay XY. Meron na bang partnership? The answer is no. Kasi yung distribution dito is just an incident to the existence ng co-ownership. Kaya nga sinasabi dito, di ba? Co-ownership or co-possession does not of itself establish a partnership, whether such co-owner or co-possessor do or do not share any profit made by the use of property. Kasi yung na-generate na profit ng property, incident, nung dinistribute among co-owners, are merely incidental sa existence ng co-ownership. Pero kung halimbawa, may case na ganito. Si A, for instance, namatay. Okay, namatay kunwari si A. Meron siyang naiwang property kay X and Y. Ang problema, di syempre X and Y becomes co-owner of undivided property by operation of law. Ang problema, later on, si X and Y, nag-contribute sila ng cash, okay, para i-develop yung property at inoperate nila to as a resort. Okay? I-operate as resort. Eh, ang problema, okay, nakita ng BIR kunwari, di tinax ngayon as corporation. Pero ang sabi naman X and Y, wala namang corporation dito. This is just, okay, a co-ownership. Eh kasi kung halimbawa may unregistered partnership dyan, taxable as corporation. Eh kaso kung co-ownership, eh hindi sila taxable as corporation. Pero lumalabas taxable lang yung mga co-owner in their individual capacity. Part ng gross income lang nila. Kaya ang question dito ngayon, meron na bang unregistered partnership? Okay, may isang case na yan, ang sabi is yes. Kasi na-convert ngayon yung co-ownership into unregistered partnership. Kasi lumalabas, nag-contribute na sila ng money, property, or industry to common fund at ang intention nila ay i-divide yung profit among themselves. Okay, iba naman yung unang scenario na nag-generate ng profit yung property pero that is just an incidental sa existence ng co-ownership. Pero yung pangalawang illustration natin, nagkaroon na ng operation. Okay, nag-contribute sila, dinevelop yung property, tapos inoperate nila as resort, nag-engage na sa operation. Nag-engage sa trade or business. In that case, magiging unregistered partnership, that's why taxable as corporation siya. Now, the sharing of gross return daw does not of itself establish a partnership, whether or not the person sharing them have a joint or common right or interest in any property from which the returns daw are derived. Kaya kung nag-share kayo ng gross return, wala lang. Pero take note, the moment na nag-share kayo ng net profit, mag-create na siya ng prima facie presumption of existence ng partnership. Kaya ibig sabihin, pag nag-share na kayo ng net profit, may presumption na isa kang partner. Pero mawawala daw tong presumption na to. Wala raw presumption dito na may partnership kung nagkaroon ka ng share sa profit in payment of drawing. Ano ba yung drawing? Yung D stand for debt on installment. R is rent to a landlord. Okay. W is payment of wages. Okay. Tapos, okay, A is annuity. Nakalimutan ko yung A, annuity. Okay. Annuity to a widow or representative of a deceased partner. Yung I, N naman is interest. And G is disposal ng goodwill. Kasi halimbawa, tumanggap ka ng share sa net profit, pambayad pala ng debt on installment. Di ang relationship nyo is debtor-creditor relationship. Okay, tumanggap ka kanwari ng share sa profit, pero pambayad pala ng rental. Kaya ang lumalabas na relationship ay lessor-lessee relationship. Tumanggap ka ng annuity. Tumanggap ka ng share sa profit, pero okay, pambayad dito ng annuity para doon sa share ng deceased partner. Eh di lumalabas assignee of interest ka lang, hindi ka partner. Okay, tumanggap ka ng share sa net profit pero pambayad pala ng wages yan. Eh di merong employer-employee relationship. Okay, tumanggap ka ng share sa net profit, pambayad ng interest, eh di debtor-creditor relationship ulit. O kaya tumanggap ka ng share sa net profit, pambayad pala ng disposal ng goodwill, lumalabas, wala pa ring partnership. Kasi talaga, ang test talaga natin dito, kung meron bang partnership is, are you sharing in the net profit as co-owner ng business? Pero kung pag ang sagot mo yes, then is, you are a partner. Pero kung tumatanggap ka ng share sa net profit, hindi naman co-owner ng business, pero pambayad lang ng debt, okay, debt, okay, rent, annuity, wages, interest, disposal ng goodwill, it means there is no partnership. Pero actually, tingnan mo ha, medyo may dividing line kasi talaga dito. Okay? Na dapat i-prove mo. Bigyan kita ng example. Halimbawa, sabi ko, nagtumanggap ako ng share sa net profit. Siyempre, ang contention ko, partner ako. Okay? Kasi ang contribution ko, kunwari, sabi ko, yung building. Pero sabi naman ng kabila, hindi ka partner kasi tumanggap ka ng shares sa net profit, pambayad ng renta yan. Renta ng building. O di syempre, kung ikaw yung judge, sinong papaniwalaan mo? Yan ba ay renta talaga? Or isa ka talagang partner at ang contribution mo, yung building, yung property, yung use ng property. Kaya dito, okay, kailangan nang i-prove yan. Okay? Depende na kung ano mga ebidensyang i-represent mo. Okay, kung halimbawa, in addition to that, diba, siya yun nga, pinapagamit mo yung property, okay, tapos nakakapag-inspect ka ng mga records ng partnership, it means na hindi ka lang as a mere lessor, but rather, you are a partner. Pero yun nga lang, mawawala yung presumption dito na may partnership once na, okay, tumanggap ka ng share sa net profit, pambayad ng mga item na to. Okay? Pero syempre ang rule kasi, once na nag-share ka sa net profit, may prima facie presumption kagad that there is a partnership. Okay? Ngayon, a person who receive the profit is always a partner? Of course, the answer is no. Okay? Hindi naman, may presumption lang. Pero hindi always a partner. Kasi yun nga, kasi kung pambayad kunwari nga yan ng rent, okay, or annuity debt, it means there is no partnership and you are not a partner. Iba ang relationship niya. Pero in the absence of any contrary agreement, the rule is that once nag-share ka sa net profit, may presumption ka agad that you are a partner. Kaya I repeat, ang test natin na is this. It is not merely the sharing of profit, but rather the sharing of them as co-owner of the business that makes one a partner. Hence, the test is, does the recipient of profit receive it as a co-owner proprietor of the business? If the answer is an affirmative, a partnership exists. Okay? Now, kaya i-check nyo muna yun. Kaya titingnan nyo sa problem kung tumanggap ka ng share sa net profit, okay, as co-owner ng business, lumalabas, there is a partnership. Okay, at isa kang partner. Kaya normally dapat may mutual agency din. Kaya pwede mong i-represent, pwede mong i-represent yung other partner as well as the partnership. Okay? Now, let us discuss kinds of partnerships. Kind of partnership as to liability of partners, pwede raw siyang general partnership or pwede siyang limited partnership. Pag general partnership daw, ito yung partnership na composed ng all general partners. At ang general partners are liable to the extent of their separate property. Pero pag limited partnership, ito yung partnership na composed ng at least one general partner and at least one limited partner. Kaya hindi kayo pwedeng mag-form ng limited partnership wherein all partners are general. At di ka rin pwedeng mag-form ng limited partnership wherein all partners are limited. Kailangan combination siya ng both general and limited. Kaya dapat at least one general partner and at least one limited partner. And take note, a limited partner is liable only to the extent of his capital contribution. Pero by the way, bago nyo ma-form ang limited partnership, kailangan i-comply nyo lahat ng requirements set forth by law. At merong dalawang requirement ang pag-form ng valid limited partnership. First, kailangan meron kayong sworn statement na naka-indicate substantially all the requirements set forth by law. Meron yung tinatawag na Article of Co-Limited Partnership. Tapos pangalawa, kailangan niyang i-submit before the Security and Exchange Commission. By the way, kung hindi nyo na-comply yung dalawang requirements set forth by law, may valid partnership pa rin naman. Pero general partnership lang. Kaya lumalabas, all partners in this case are liable to the extent of their separate property. Okay? Pero walang limited partnership. Kasi kailangan nyo i-comply yung dalawang requirements set forth by law. In fact, kailangan nyo comply ng substantial compliance. Kasi pag wala kayong substantial compliance nun, it means only a general partnership is formed. Pero tandaan nyo, kung may nag-contribute ng immovable property at walang inventory ng real property signed by the partners and attached to the public instrument, then the partnership is null and void. Kasi yung Article 1771 in relation to 1773, dapat, okay, applicable yan sa both general and limited partnership. Kasi pag hindi nyo na-comply yung form prescribed ng 1771 in relation to 1773, lumalabas, walang valid partnership. Okay, as to duration, pwede raw siyang partnership at will or partnership with a fixed term or particular undertaking. Ngayon, pag partnership at will daw, ito raw yung partnership, okay, na wala kayong agreement ng specific period, okay, or particular undertaking. Kaya lumalabas, pwede siyang i-dissolve at any time without committing a breach of contract. Pero pag partnership with a fixed term or particular undertaking, dalawa yan ha, pwedeng halimbawa, si ABC nag-form ng partnership with a fixed term of 5 years. Or pangalawa, si ABC nag-form ng partnership, ang gagawin nila, magko-construct lang sila ng building, ibibenta lahat ito, okay, and after that, dissolve. Yan yung tinatawag na partnership with a specific undertaking or particular undertaking. Ngayon, question nga pala, ABC nag-form ng partnership with a fixed term of 10 years. Nakaka 3 years pa lang sila, pwede bang mag-withdraw si A? Answer of course is yes. Pero yan nga lang, pag nag-withdraw ka, take the consequence of your action. Kaya ang effect, the partnership is dissolved. Pero liable si A for breach of contract. Kasi lumalabas, nag-withdraw ka before expiration ng term. Okay? Kaya merong breach of contract. Kaya you can be held liable for damages for breach of contract. Pero ang rule is that, pwede ka pa rin mag-withdraw because no person shall be compelled to become a member of the partnership. Remember, partnership is based on a fiduciary relationship. Kaya kung wala ka ng trust and confidence with the other partners, you can withdraw at any time. But take the consequence of your action. Unless meron kang grounds for judicial dissolution. Next, as to extent of its subject matter, pwede raw siyang universal partnership or pwedeng particular. Pag universal partnership daw, ito raw yung, okay, pwede siyang universal partnership of all present property or pwede siyang universal partnership of all profits. Okay, pag particular naman, ang particular partnership, ito raw yung partnership na may determinate object, their use or fruits, or specific undertaking or exercise of profession or vocation. Paki-check nyo maigi yung definition ng particular. Ito yung partnership na may determinate object, there is and fruit, particular undertaking, or exercise ng profession or vocation. Okay, kung hindi siya nag-fall dyan, then that is a universal partnership. Okay, actually kung tingnan mo na lang is universal. Pag di nag-fall sa definition ng universal partnership, whether of all present property or all profit, then that is a particular partnership. Okay, ngayon, ano ba ang kasama sa universal partnership of all present property? Sabi kasi ng batas, sa universal partnership of all present property, lahat daw ng existing property ni A, lahat ng existing property ni B, at lahat ng existing property ni C, lahat yan ay magiging part ng common fund, as well as the fruits of those existing property. Pero ang question, how about future property? Kasama ba yan as part ng common fund? The answer is obvious. No. Bakit? Because we're talking of present property, not the future. Kaya ang rule, yung future property, excluded dyan as a rule. Pero ang tanong, pwede ba siyang isama? The answer is yes, kapag may stipulation. Kaya pag may stipulation, kasama. Pero pag walang stipulation, excluded siya. Okay? Pero, okay, kahit merong stipulation, hindi nyo pwedeng isama yung mga property subsequently acquired kapag galing yan sa inheritance, legacy, saka donation. Only the fruits. Kaya ibig sabihin, kung merong agreement na kasama ang mga future property, pero galing yan sa inheritance, legacy, saka donation, excluded pa rin. Pero yung fruits ng property coming from inheritance, legacy, donation may be included. May tanong ako. Ano ba yung common denominator nitong tatlo? Answer, mapapansin mo, lahat yan ay gratuitous transfer. Kaya ibig sabihin, kung yan ay future property, pero galing sa property, okay, yung property subsequently acquired ay galing sa onerous transfer. kasama siya. Kung may stipulation. Pero syempre kung wala pa rin, edi nandito ka. Walang stipulation, excluded siya because we're talking only of present property, not future property. How about universal partnership of all profit naman? Sa universal partnership of all profit, lahat daw ng property na kinontribute ng partners, ang ownership niyan, nasa kanila pa rin. Okay? Kasi ang magiging part ng common fund is only the fruits of those property contributed. Kaya, okay, fruits lang ng mga kinontribute nilang property at lahat ng ma-acquire nila subsequently na coming from work or industry. Kaya tandaan nyo, sa universal partnership of all profit, ang kasama as part ng common fund is yung fruits ng property contributed. Saka pangalawa, lahat ng ma-acquired nila subsequently na galing from work or industry. Ngayon, tandaan nyo na ang universal partnership daw, whether of all present property or all profit, ang nature daw niyan is like donation. That's why those who are prohibited to give donation to each other cannot enter into a universal partnership. Sino ba yung mga prohibited to give donation to each other? Siyempre, nangunguna lang si husband and wife. Okay? Between those who are guilty of adultery or concubinage. Okay? Between those persons found guilty of the same criminal offense. Adultery or concubinage in consideration thereof, and between a person and public officer or his wife, descendant and ascendant by reason of his office. Kaya tandaan nyo ha, itong mga to, mga prohibited yan to give donation to each other, kaya bawal silang mag-enter ng universal partnership, whether of all present property or all profit. Pero take note, they are allowed to enter into a particular partnership. Kasi ang prohibition lang is universal, whether of all present property or all profit. By the way nga pala class, what if nag-entered kayo ng universal partnership? Pero walang naka-indicate whether of all present property or all profit, ang presumption ng batas, nag-entered lang sila ng universal partnership of all profit. Kasi since gratuitous yan, okay, dapat ang interpretation must be the least transmission of right. Kaya, tingnan mo itong case ng Commissioner of Internal Revenue versus William J. Soter. William J. Soter Morcowin Company Ltd. Was organized on September 13, 1947 as a limited partnership. Okay, and it composed of William J. Soter as general partner, Julius Spirig as limited partner, and Gustav Carson as limited partner. In 1948, William J. Soter and Julius Spirig got married. And ang question is that, yun bang subsequent marriage between Soter and Spirig a ground for automatic dissolution? Okay? Ang sabi ng BIR dyan, Commission on Internal Revenue, okay, lumalabas, dissolve ba siya? Sabi ng Supreme Court dito is, hindi siya magkukos ng dissolution. Why? Because this is just a particular partnership. Okay? Kaya walang prohibition. Ano ba yung particular? Ito yung partnership na may determinate object, there is in fruit, particular undertaking, or exercise ng profession or vocation. Limited partnership may specific contribution yan. Kaya particular lang. Kaya lumalabas yung subsequent marriage between Soter and Spirig is not a ground for automatic dissolution kasi walang prohibition. Pero by the way, pakicheck nyo maigi yung problem kasi baka mamaya, okay, yun palang finorm na partnership universal. Kung universal yan, whether all present property or all profit yung object ng partnership, yung subsequent marriage ng partner, ground dyan for automatic dissolution because they are prohibited to enter into a universal partnership. Kasi di ba husband and wife prohibited na mag-donate to each other. Ang problema kasi ang nature nga ng universal partnership parang donation yun. Kaya magkakaroon kayo ng indirect donation dito which is prohibited by law. Okay? A and B, Okay, nag-form ng partnership, universal partnership of all present property. Sabi niya, no stipulation was made regarding other properties. Subsequently, A received a parcel of land by inheritance from his father and another parcel of land from FEU as remuneration for A's work as professor there. Question number 1, are the two parcel of land and their fruits to be enjoyed by the partnership? Of course, no. Kasi lahat yan ay property subsequently acquired, kaya excluded because we're talking of present property. Number 2, what if it was stipulated that all property subsequently acquired would belong to the partnership? Okay, kasama na ba? Yung first item, yung unang land na galing sa inheritance, excluded. Pero yung fruits, kasama. Pangalawa, yung land coming from FEU, included. Pero yung fruits, included pa rin. Kasi ang excluded lang dito ay yung parcel of land coming from inheritance. Kasi since meron ng stipulation, okay, regarding property subsequently acquired, kasama na siya. Pero hindi nyo pwedeng isama yung mga property subsequently acquired na galing from inheritance, legacy, and donation. Only the fruits. Pero since ito galing sa onerous transfer yan, kasi galing from remuneration, included yung mismong property as well as the fruits. Pero ito, only the fruits. Kasi galing sa inheritance, yung parcel of land. By the way, huwag kayong ma-confuse nga pala. Okay, ang pinag-uusapan natin dito na galing sa inheritance legislation excluded, yung mga property subsequently acquired. Kasi baka mamaya, na-inherit mo na pala. Tapos doon ka nag-form ng partnership, kasama yun. Kasi lumalabas, present property mo yun. Okay, how about universal partnership of all profits naman? Halimbawa si AB, nag-form ng universal partnership of all profits. Scenario number 1, he contributed the use of his car. At the end of the partnership, should the car be returned to him? Okay, the answer of course is yes because the ownership of the car still belong to A. Kasi ang transfer lang niya sa partnership is only the use. Scenario number 2, subsequently A won first prize in the sweepstakes. Will the money belong to the partnership? The answer is no. Kasi hindi naman yan galing sa work or industry. Wait lang. Okay, I repeat. Okay, bali, yung scenario number 2, okay, subsequently A won first prize in the sweepstakes. Will the money belong to the partnership? The answer is no. Kasi hindi naman siya galing sa work or industry. Kasi remember, pag universal partnership of all profit, ang kasama lang is yung fruits ng property contributed, saka lahat ng ma-acquired subsequently na galing from work or industry. Eh kaso game of chance yan, kaya excluded. Scenario number 2, subsequently A becomes a professor at the Assumption College. Will A salaries belong to the partnership? The answer is yes. Kasi galing na yan sa work or industry. And scenario number 4, A purchase a parcel of land. Will the fruit of said land belong to the partnership? Is no. Okay, hindi siya kasama. Okay, pero pwedeng isama kung merong stipulation. Okay, kung yan ay property subsequently acquired. Okay? Now, ito, okay, tapusin natin. After representation to others daw, pwede siyang ordinary or real partnership. Sabi dyan, one which actually exists among the partners and also the third person. Pero pag ostensible or partnership by estopel, sabi dyan, one which in reality is not a partnership but is considered a partnership only in relation to those who by their conduct or omission are precluded to deny or disprove its existence. As to legality of existence, pwede raw siyang de jure or de facto. Pag de jure, it means kinomply daw all or substantially all the requirements set forth by law. Pag de facto, hindi na-comply all or substantially all the requirements set forth by law. As to publicity, pwede raw siyang secret partnership, one wherein the existence of certain person as partner is not avowed or made known to the public by any of the partners. Pag open or notorious partnership naman is one whose existence is avowed or made known to the public by members of the family. As to purpose, pwede raw siyang commercial or trading partnership or pwede siyang professional or non-trading partnership. Ito yung first paragraph ng Article 1767. Ito yung second paragraph. Ordinary partnership. Ito naman is the general professional partnership. Okay? Break muna tayo. Gawa na lang ako ng second video. Okay?